You think you're not competent to stand trial?
At this point, I am schizoaffective, and at this point, I probably am not fit to stand trial.
Well, the legal standard for that is whether
I've been legally diagnosed for years at this point.
Today's case is packed with drama on assault charge, with a weapon, a long criminal history, and now the defendant turns on his own lawyer, claiming his rights were ignored. From the very start, the tension is high. Is this about justice or strategy?
Have you had a chance to review the charging information with Mr.
I've given Mr. Colpine a copy of his information, and Mr. Colpine would like it read into the record.
Okay, very good. Mr. Colpine, it is alleged that you have, by the people of the state of Michigan through the prosecuting attorney, that you have committed the following offenses on or about August 14th, 2024 within Kohler Township, County of Sheboygan. In count one, it's alleged that you did make an assault upon John Daniel Ramsey Jr. with a dangerous weapon, to wit, a stick, but without intending to commit the crime of murder or to inflict great bodily harm less than the crime of murder. That is a felony. The prosecutor has also filed a habitual offender notice, habitual offender third. It alleges that you've been previously convicted of a felony or attempt to commit a felony, in that on or about July 26th, 2022, you were convicted of criminal sexual conduct in the fourth degree with an incapacitated victim in violation of law in the 53rd Circuit Court for the County of Sheboygan. Also, that on or about October 24th of 2023, you were convicted of the offense of assaulting, resisting, or obstructing a police officer in violation of law, also in the 53rd Circuit Court for the County of Sheboygan. Based on that habitual offender third, the maximum for the felonious assault allegation, Mr. Colpine, is a felony punishable by up to 8 years in prison and or a $2,000 fine. Do you understand the maximum penalty that charge would bring, sir?
Yes, I do.
All right. And do you know how Mr. Colpine wishes to plead to that charge?
He'll stand mute.
Okay, the court will enter a plea.
No, I will plead not guilty, Your Honor. And I would like to say that Gilbert has been a very not good lawyer at this point, and I would like to request a new one from the Public Defender's Office because he is doing an inadequate job. He has allowed my Sixth Amendment right to be done, my preliminary exam to be done with evidentiary hearing and preliminary exam done after my 22 days of allowment. So I am not being adequate.
This is where things heat up. The defendant blasts his attorney in open court, but the judge isn't buying it. Legally, disagreements or missed deadlines aren't enough to replace counsel. What do you think? Should defendants have more control, or does the judge have it right?
Represented by him.
Okay, well, I will accept your no contest, your not guilty plea, and enter a plea of not guilty for you as to count one, the habitual notice. And as to your request for substitute appointed counsel, the only basis that you stated for that was a waiver of a time requirement. And Mr. Colpine, the law is pretty clear that waivers of procedural time requirements like that
I did not waive my right. It was forced.
Hang on, now you're interrupting me. Are rarely, if ever, grounds to replace an attorney. So is there anything else you want to tell me about that? Sounds like you wanted to.
Well, at this point, me and him have gotten into an argument right there, and he is not even adequately doing that. At this point, I should have had, within the 56 days that I've been here, should have been farther in the legal judicial system line than I am at this point. And I would also like to request that I be put on for jury selection at this point too.
Okay. All right, so I'm going to deny your request for substitute counsel for the reasons that I stated there. And Mr. Gilbert, is a forensic center referral requested?
I don't believe it's necessary.
Yes, Your Honor, I would like to request that.
Well, do you know what that is?
Yes, it's going to be psychological examination.
You think you're not competent to stand trial?
At this point, I am schizoaffective, and at this point, I probably am not fit to stand trial.
Now, the defendant plays the mental health card, claiming schizoaffective disorder. But competency isn't about diagnosis. It's about understanding the charges and helping in your defense. The judge points out the defendant clearly knows the system, smart delay tactic, or genuine concern.
Well, the legal standard for that is whether
I've been legally diagnosed for years at this point.
The legal standard for that is whether you're capable of appreciating the charges against you and whether you're able to assist rationally in your own defense. I don't see any indication that you're not. I explained the charges against you. You told me you understand them. And you explained to me the reasons why you'd like Mr. Gilbert to be doing an even better job for you than he's been doing. I think that you have you're talking about time requirements for a preliminary examination. You're talking about jury selection in a speedy trial. That displays a fairly sophisticated knowledge, Mr. Colpine, about how the criminal process works, and that you demonstrate, to my mind, a very strong ability to assist rationally in your own defense. So I will not be referring this to the Forensic Center for evaluation at this time. What would be the estimated length of trial, Mr. Gilbert?
I think max with jury selection would be 2 days.
Ms. Goodrich, do you concur?
I would.
Looks like what's Mr. Colpine's bond status right now? Looks like there's a judgment of contempt in the sentence from August. Is he serving a contempt sentence right now?
He was on contempt sentence, but he has to be coming fairly close to the end of that.
It was a 93 days back on August 15th. So he's probably still got a couple more weeks at least.
Oh, you'd have to be 78, so yeah, he's got about 23, I believe.
Okay, and then is he sitting on that, or is there a bond revocation issue that happened in district court as well?
I believe that's all he's sitting on, if I remember correctly from my review.
Okay. Oh, and then the bond was not posted though.
Correct.
Okay. Schedule it for November 5th at 2:10 in the afternoon. People be Michael Lefebvre. 24-6895. We're up for a docket call, and also Mr. Lefebvre, it's alleged that you are in contempt of court for failing to comply with the, go ahead and stand up while I rein this, for failing to comply with the conditions of your bond, in that you've been non-compliant on the bond line. Looks like some missed calls and missed tests. You have the right to have a hearing on those allegations where they would need to be proven beyond a reasonable doubt, and the right to the assistance of your attorney if I find and cross-examine the evidence against you and present evidence in your own defense. If I find you to be in contempt, I could jail you for up to 93 days and or fine you for up to $7,500. Also, if I have reasonable basis to believe that you're not complying with the conditions of your bond, I can revoke that bond. And so, Ms. Libby, with Mr. Lefebvre being advised of his rights and possible penalties, do you know how he wishes to proceed on contempt?
Yes, Your Honor. I did discuss this allegation of contempt with Mr. Lefebvre. At this time, he would enter a plea of not guilty.
Okay. And where are we at on the underlying docket?
On the underlying docket call, Your Honor, we did receive an offer from the prosecutor's office in this matter as well. We recently received some toxicology reports through discovery. So I haven't had an opportunity to go through those specific reports with Mr. Lefebvre. If I could request an additional docket call, we may be headed towards resolution.
We could schedule this for, well, I guess maybe first I should get some input. So this is a case involving a drug possession and also an allegation of an OUID with a minor in the car. And it looks like we're not getting any testing from Mr. Lefebvre. Can somebody explain to me why I should not revoke his bond right now?
Your Honor, as to Mr. Lefebvre's bond, the intent of the forthcoming hearing on contempt is to determine for the court whether Mr. Lefebvre fully understood that the transfer of his file from the district court to the circuit court was in full maintenance of his bond that was originally ordered. Mr. Lefebvre may have been confused about the requirements upon shifting between the courts, that they will remain the same. And I believe Mr. Lefebvre is back on track with calling the bond line. In fact, he has a test today. So, Your Honor, I would ask the court to maintain his release on bond pending that hearing.
Mr. Juliet, is this your matter then?
It's Goodrich.
Oh, I'm sorry. Well, this is an OUID. So you don't,
It's
okay.
not a third.
Oh,
second.
okay. It's only, all right. Ms. Goodrich, people's position.
Your Honor, the concern here is that it is an OWI involving a child in the car, based on allegations, as well as a drug possession case. I guess anybody could say, hey, I didn't know I was supposed to continue calling from district court to circuit court. I'm not sure that the court wants to have that be a basis for excusing a bond violation. So I would ask that the bond be revoked at this time.
Yeah, I agree. I mean, this is a serious matter, and we got a month where you're not even testing or doing anything for us at all, and that's a quite silly excuse. You're remanded to the custody of the sheriff. I'll see you on November 5th at 10:40.
In the end, the judge comes down hard revoking bond and sending the defendant back to jail. From not guilty pleas to lawyer drama to mental health claims, this case had it all. Was the judge too harsh or exactly right? If you enjoyed this, break down, hit like, drop your thoughts in the comments, and don't forget to subscribe for more courtroom drama.